Or is it making a disclosure, or at the time of filing the application you then indicate which parts of, if it were plain, which parts are being amended?
Rightly so, my lady.
That's what you're calling a disclosure?
Yes, they would actually, yes, disclose by either striking out
All
or
right.
underlining.
Fine, that's okay. Now, when it comes to the Law of Succession Act, there is a deceased person who died intestate, and there are two administrators who went to court to apply for letters of administration. The court did issue the letters of administration and subsequently confirmed the grant. Then they discovered that there is a property that was left out, the property of the deceased person. How do they go about amending the confirmed letters of grant, if at all?
They would have to apply before the court through an application, chamber summons application, disclosing or showing the property that was left out, the ownership, to affirm or confirm that the ownership of the property still belongs to the deceased person, and they would also have to demonstrate the reasons why it was inadvertently omitted in the first instance, and include or demonstrate how the distribution would be.
So if you are a judge and you are faced with an application where administrators are applying to include one of the properties that has been left out, tell us how you would determine that matter.
I would look at all the facts that are presented before me. I would analyze the evidence carefully. I will employ the principles of equity and oxygen principles to make sure that justice is done with respect to the inclusion, so that the benefit of those parties when it comes to that property that was omitted can be included. And so I would also,
maybe in the interest of time, so that we don't waste a lot of time, I can just ask a specific question. Can confirmed letters of grant be amended?
The confirmed letters of grant can be amended by way of consent if all parties agree to the actual amendment.
They are not in agreement?
Pardon me, my lady?
They are not in agreement?
Or the two parties are not in agreement?
Yes, yes.
If they are not in agreement, then I would have to analyze and apply the law.
So what you're telling us is that an application comes before you, you look at all the surrounding circumstances, and if it is true that the property of a deceased person was left out, you can amend the confirmed letters of grant.
If there is a dispute to if there is a dispute with respect to the amendment of the grant, so I would have them apply for a fresh grant on the said property.
Are there instances when you can amend the grant?
Yes, there are instances.
Okay, which are those instances?
When there is a material non-disclosure, or when the property is not known to the parties before who were.
So you can bring it on board?
when
You can include it as amongst the assets of the deceased.
yes,
That is not entirely correct, eh? That is not correct, that if property is left out, then an application to amend, then you can then bring it on board. The law of
Stand guided,
succession
my
does
lady.
not allow you to bring on board property that was left out in the confirmed letters of grant. But you can rectify that grant in certain circumstances, excluding the bringing on board of a property that was left out. And the question then is like, what are these instances when you can amend the confirmed letters of grant?
for rectification, the instances would be if there is a change of the beneficiaries who are to benefit from the said estate. There is also the issue on knowledge of the property. If it becomes known that the property is in existence, it can also apply.
But that's what I've told you, that you cannot do that. You cannot bring on board property that was not listed as amongst the assets of the deceased when you are seeking amendment to amend the confirmed grant. It confines itself to issues that are straightforward, say in terms of the names of the parties, the description of the parties, the place and time of death of the deceased person, but not fundamental issues like bringing on board property that was left out or bringing on board beneficiaries who were left out. So you may need to check on that, on the law of succession. And then finally from me, imagine that you've been successful and you are conducting a murder trial. One of the witnesses in court has turned hostile. What do you do as a trial judge?
I would have a trial within a trial to establish the evidence that this witness will bring.
We are not talking about a confession. A retracted or repudiated confession would call for a trial within a trial, but here we are talking about a hostile witness. There's a distinction, eh?
Yes.
Yes.
A hostile witness would be a witness who has gone rogue and is not acting in accordance with the laid down procedures in as far as the witness statements is concerned. And in this instant, the court in question where I will be, I will request the prosecution to either stand down the witness and to understand why the reason behind them not being able to, if they don't want to participate in the proceedings as witnesses, so that there is a progression on the matter, and in understanding why the witness is hostile, the case will have substantial progress in my view.
So what you're saying is that you will dispense with the evidence of that witness?
Not entirely, my lady.
Explain to us, when you say not entirely, what do you mean?
It will only be dispensed if the prosecution allows or deems it fit.
You are the one in charge. It is your court. There is a witness who has turned hostile.
Yes.
And then I was asking you, or I'm asking you, what do you do when a witness has turned hostile? You've said you stand down that witness. So I'm asking, then do you dispense with the evidence of that witness?
No.
What do you do?
You would have the prosecution understand why the witness has turned hostile. Probably they do not want to participate give evidence.
But the prosecutor is in court and he also appreciates that the witness has turned hostile.
I would probably, in terms of understanding the reasoning why they have turned hostile, my lady, I would have it indicated in the record of the court that the witness is hostile, and also proceed to demonstrate the reasoning why they've become hostile before I discharge the witness.
Okay, thank you, but I think you need to check on that. All right.
Thank you, CJ. Counsel, I have one or two questions. The first is, can a counterclaim survive the withdrawal or dismissal of the main suit?
Come again?
Can a counterclaim survive the withdrawal or dismissal of the main suit?